Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. It has been widespread in the news items that Supreme Court is formulating a committee to decide the issue of freebies or free gifts. How this has emanated, what is the root cause, and what are the legal aspects. It has got political as well as legal aspects also. So I am discussing only the legal point, that's all. Right. On 24th of August 2022, Honorable Chief Justice of India, Shri N.V. Ramana bench stated that they want to discuss the freebies issue basing on the public interest litigation filed by Ashwini Kumar Upadhyaya, BJP MP. And very recently, the Prime Minister of India, Shri Narendra Modi, he also commented against to the freebies culture. So you all know, freebies are nothing but free gifts. Every political party, during the elections, before the elections, they will declare or they will announce in their manifesto regarding the freebies. Right. Now we are reminded of the 2013 Balaji judgment, Mr. S.Subramaniam Balaji versus State of Tamil Nadu 2000 judgment, where two judges, both of them became the Chief Justice of India also. So Mr. Sadashivan and also Ranjan Gogoi, they held that the freebies cannot come under the purview of the corrupt practice. The political party is not responsible, and the concerned candidate will be held responsible if the freebies are discussed or if they are announced. So that is the decision as per section 123 of the Representation of the People Act. You may be knowing section 123 of the Representation of the People Act, it deals with the so-called corrupt practices like bribery, whether directly or indirectly. I will tell you the section in the appropriate time. Now, we all of us are reminded of this S.Subramaniam Balaji versus State of Tamil Nadu 2000 judgment. So, Supreme Court has to revisit the case. What is this case? Better discuss. Right. Actually, during the assembly elections in 2006, the DMK party, Dravida Munnetra Kazhagam or Kalagam, they pronounce it. So DMK party, they announced freebies in the name of the scheme of color TVs to every household who do not have the color TVs. So they will distribute the color TVs for each and every household which do not possess the same. So this was challenged by Balaji as unconstitutional because the expenditure, who will bear the expenditure? The government. It means the exchequer on the part of the government, around 750 crores or so they have spent already. So it is nothing but public money, waste of public money. So in the name of freebies, you are spending the public. If you are spending your party money, it's okay. But you are doing this as government, it should not be allowed. That is this contention, because the amount will be deducted from the state exchequer. Therefore, it is unauthorized, it is impermissible, and should be declared as ultra-vires. The freebie scheme should be declared as ultra-vires. But before deciding the same, DMK came out successful and it emerged victorious in the elections in May 2006. So, as promised, they have delivered 14 inches color TVs to each and every household which do not have the color TVs. So they have placed an order to the ELCOT, Electronic Corporation of Tamil Nadu, SIPCOT, ELCOT, you may be knowing, they are located in Tamil Nadu. Yes, they have given orders. Ultimately, they have spent about 750 crores and purchased 30,000 color TVs, right? So, therefore, petitioner says, at least you wake up, it is unconstitutional, right? Now, here, it was also commented by the Auditor and Comptroller General of India. You may be knowing, Article 148 says it is a constitutional provision. They have to audit the income and expenditure of each state. Of course, this is only advisory body. The state may follow his directions or may not follow his directions also. Right. So please remember now in this connection the provisions of section 123 has been discussed in this Balaji case. Please remember section 123 is what is bribery, what is corrupt practice. If any gift, offer or promise of gratification either directly or indirectly made by a candidate or his agent or any authorized person acting on his behalf to any voter, yes, it is a corrupt practice. But here the freebies are given in the name of welfare measures. Now the conflict or the dichotomy. Actually, this judgment also clearly asked the Supreme Court of India to clear the dichotomy between the candidate and the political party. Right? Candidate, actually, as per 123 of the Representation of the People's Act, the candidate who promised to give the freebies, who promised to bribe the voter, he will be held liable. But can a candidate declare like that without the permission of the party? Will he spend his own money, the party, or the government has to spend their money? Therefore, the political party should be made accountable. The dichotomy between the candidate and party should be clear. The air should be clear. This is also another contention by Aravinda Datar, who appeared on behalf of this thing. Right? So, Supreme Court, of course, today is the last day for the functioning of the CJI Sri N.V. Ramana. He has clearly stated that every political party is interested. It's the main problem. Even though Ashwini Kumar Upadhyay, he filed the petition, every political party is interested in giving the freebies in the name of the so-called welfare measures or directive principles of the state policy, welfare of the public. And it is very difficult to differentiate between a freebie and the welfare measure. Suppose if you give cycles freely to the school girls, do you mean to say that it's a freebie? So many girls, they are coming from the villages and getting themselves educated. Suppose if you supply some instruments to the the barbers or washermen, do you say that it's a freebie? Then you go to the villages, rural areas, yes, definitely there are so many people who do not have the instruments due to which they are not able to perform their customary practice. Like with subsidies. So all these things are mixed. So there should be some differentiation between a freebie and the welfare measure. Therefore, Honorable Supreme Court of India wanted to constitute a board to discuss the issues. Of course, today is the last day for CJA. Whether the board will be constituted, whether they will discuss the matter or not is a different thing. But here, once again, we are reminded of the landmark judgment of S.Subramaniam Balaji versus State of Tamil Nadu 2018, basing on the petition public interest litigation filed by Ashwini Kumar Upadhyay. So, friends, normally we call it as Balaji judgment, but don't be confused. Balaji judgments are three different judgments are there. A.K. Balaji versus State of Mysore, there is a reservation. Then Balaji versus India, that is advocates of foreign countries practicing in India. I will make videos in those two cases also, and definitely you will get enriched with the legal knowledge. So please read the judgment of S.Subramaniam Balaji as a precursor to this freebies scheme, and then definitely you will understand whether freebies are necessary or not. Okay, thank you very much.